Hi there, Alex Cuculici here with hopefully some interesting information as it applies to the case of Park v. Duran. Today we're going to be talking about Rule 405. It can apply to other cases besides just this case. I think it's a pretty in-depth argument, but one that can be made that follows logically, that could have a lot of implication, not just in this case, but down the line. But just for reference, I'll be using Park v. Duran in my explanations at the moment because this rule directly applies to this case in lots of different ways. I'm going to pull up the Rule 405, real quick. So for those of you who have been watching and watched before, you'll remember that the 400s are relevance, and that Rule 404 specifically deals with character evidence, namely evidence that is being introduced in trial to show that because an individual did something on one occasion, they did so in the occasion we're trying them for now. Evidence of that sort is called propensity or action in conformity therewith, and is inadmissible under Rule 404A. Rule 404B provides numerous exceptions to character evidence or alternate purposes besides propensity that evidence of a person's trait of character or past actions can be used for. Rule 405 does not comment explicitly on admissibility. We talked about this generally in the character evidence video, but in Rule 405, and people get this wrong all the time, it isn't that all reputations and opinions, as you can see 405A's title is here. And it's not that all specific instances of conduct are admissible character evidence. Rule 405 merely governs the method by which admissible character evidence determined by Rule 404A and B can be introduced. And with that knowledge, we'll get to reading. The first method is via Rule 405A, by reputation or opinion. When evidence of a person's character or character trait is admissible, it may be proved by testimony about the person's reputation or by testimony in the form of an opinion. On cross-examination of the character witness, the court may allow inquiry into relevant specific instances of the person's conduct. So what this means is that on direct, if you want to elicit evidence of character, it can be done by reputation or opinion testimony. Namely, something to the effect of, I thought J.C. Longstreet, the park owner, was cheap. You might want that in because you're pursuing a claim that he defrauded taxes, and if he's cheap, then it makes it more likely. It gives him a motive for defrauding his taxes, and there's other ways to get that in, but that's an example of a reputation or an opinion. What this rule is saying is that on direct, you can offer a reputation and opinion testimony, and if someone does so on direct, offers a reputation or opinion, then it may be proper on cross-examination to delve in the specific instances that underlie that general opinion and reputation. And that's 405A. Hopefully that follows. Then Rule 405B, and that's really what we're talking about here more specifically, because this is where it starts to get interesting, in my opinion. A method of proving character evidence is not only by reputation or opinion under 405A, but also by a specific instance of conduct under 405B. Now, as it goes on to say, when a person's character or character trait is an essential element of the charge, claim, or defense, the character or trait may also be proved by relevant specific instances of conduct. Let me explain. Essentially, there's three methods of proving character included here: reputation and opinion, which are slightly different but pretty much the same under 405A, and then specific instances of conduct under 405B. An example of a reputation or an opinion is J.C. Longstreet has a reputation of being cheap, or I think J.C. Longstreet is cheap. Those would be admissible under 405A, barring that they are admissible for other reasons, which they may not be. And then 405B is a specific instance of conduct. How this would manifest in trial is, I think J.C. Longstreet is cheap because I saw him skimping on employees' pay in the past. You're commenting on a specific instance of Longstreet's cheapness as like a justification for your general opinion. You're eliciting a specific instance of prior cheapness. Now, the courts have ruled that specific instances of conduct are the most persuasive and convincing form of character evidence when it comes to juries, but that they do not hold the same weight as reputations or opinions when it comes to predicting future behavior or just generally being relevant in a case at hand. So if JC Longstreet has a reputation of being cheap, the implication is that there's a number of events that occurred over some prolonged period of time that led people to that belief and led a number of people to that belief. But one person saying one specific instance of conduct, while potentially very convincing, especially if it's something very creepy or something that would prejudice the jury against the client, one specific instance, though, isn't very predictive. It's not in science, it's not in the law either. So despite the potential persuasive nature by delving into the contents of a specific instance, it doesn't really mean as much in the law's eyes when it comes to proving someone's actual trait of character. That's why, unlike Rule 405A, reputations and opinions can always be admissible and can always be admitted. Specific instances of conduct can only be admitted, like this first sentence reads, when a person's character or trait is an essential element of a charge, claim, or defense. If you were with us with hearsay, we talked about how even if there's questions about the reliability of an out-of-court statement mentioned by a party opponent, those out-of-court statements made by party opponents, reliability aside, are so important for reaching a conclusion and determination in the case that they are not hearsay and they are exempt from that rule. That's kind of the same thing here that's being set up by Rule 405. Namely, character traits that are essential elements of the charge, claim, or defense, even if specific instances of conduct could lead the juries to be prejudiced in evaluating a specific instance, these type of character evidence that are essential elements of a charge, claim, or defense are so important that that prejudice can be ignored and specific instances of conduct can be used anyway. The second purpose is listed in 405A as a response to a general opinion that's being elicited. So that's the theory. Hopefully that followed. How this applies to Park v. Duran next. So in Park v. Duran, there is a lot of character evidence. Character evidence that in some cases is used for the purpose of medical diagnosis and coming to a conclusion as to whether Jesse Duran was or was not a psychopath, if you're talking about couples. Campbell Solo talks a lot about propensity for violence, and it's very much borderline character evidence. Much of what he says, he's another child psychologist whose conclusions essentially state that Hayden Duran had knowledge of Jesse's prior violent actions, and the warning signs were there that Hayden should have taken and responded to. We can talk about, and we will talk about in future videos, ways to get both of those character evidence in, both on solo and on couples. But how 405 applies to this. It's my contention that even if solo or couples can get those statements in under the available case law to reach their conclusions or for the purposes of knowledge, and we'll talk about a little bit more about that later, it's still not enough for them to allow specific instances of conduct to prove those methods of character evidence. And as it stands, every instance of character evidence that anyone ever uses in the case is a specific instance of conduct, whether it's Jesse Duran's tantrums, whether it's me and my gun as an illustration of violence, whether it's the disciplinary notice or the email which shows Hayden's awareness of Jesse's misbehavior. All of that are specific instances of conduct. All of it. Danny Brooks' testimony, the tantrum that he throws for Park. And because of that, an objection is ripe to be made that the method of proving character evidence is improper. Even if the character evidence is okay for whatever purpose they have a bullshit excuse for under solo or couples or whatever, that doesn't mean that it's exempt from the rules which govern the method of proving character evidence. So even if, just brief aside, couples' testimony is probably allowed because it's for the purpose of reaching a medical diagnosis. If the judge buys that argument that it's not for propensity, but it's for another purpose, essentially like a 404B exception, that's fine. He can use character evidence to reach his conclusion, but he cannot use specific instances of conduct to reach his conclusion. And that would be my objection. So imagine Campbell Solo attempts to bring in evidence of Jesse's violent behavior at school. The way I would respond is, objection, Your Honor, improper character evidence, if I may be heard. the method of proving character evidence here is improper because this is a specific instance of conduct opposing counsel is delving into, and specific instances of conduct can only be used to illustrate character evidence if the trait of character being discussed is an essential element of the charge. And in this case, the trait of violence isn't an essential element of the charge of negligent parental supervision or even intentional shooting, because there's two different charges in the Park v. Duran case. That would be my argument. The response is much easier in intentional shooting. One of the elements of intentional shooting is willful misconduct. The plaintiffs have to prove that Jesse Duran committed an act of willful misconduct, and that act of willful misconduct caused Sidney Park's death. Now, willful misconduct is the requisite mental state. And I believe you can shoehorn in, if you were to ever receive this objection while performing an intentional shooting case, you can shoehorn pretty much any example anyone talks to into willful misconduct. So the way I would respond to that objection in intentional shooting is, Your Honor, this is a specific instance of conduct, but this is permissible character evidence, and this is a permissible method because the character trait being described is willful misconduct. And willful misconduct is an essential element of the charge at hand. That's how I would respond in intentional shooting. I think that gets you by. In negligent parental supervision, it's a little bit more dicey because when you're talking about Jesse's actions, you are really offering them to show what Hayden knew about them. That gets all of that stuff in. So like the disciplinary notice evidence ends up getting overturned because it's the purpose is to show Hayden's knowledge of Jesse's misbehavior. But that doesn't get you around the 405B specific instances of conduct objection. So your objection, Your Honor, this is improper character evidence because the method isn't proper as the character trait in question is not an essential element of the charge or claim. In negligent parental supervision, you have to argue, the key thing you have to argue here, and you have to get when you're arguing this objection, is the term essential element. You're arguing about whether any element of the charge is related enough to the character trait you're talking about to make it an essential element. And there's not a lot of case law in the real world that supports this. There's none in our documents. So this is just an argument you have to have logically and reasonably about the law with opposing counsel and the judge. My argument would be trying to keep this testimony out that nothing in negligent parental supervision is an essential element of the charge when it deals with what Jesse was doing. We are here to talk about Hayden. So we can talk about how Hayden knew of Jesse's misbehavior, Hayden knew of Jesse's violence, but to talk about those specific instances of violence is impermissible under Rule 405B. I believe the response has to deal with the necessity, and it's almost a common sense argument more than a legal argument. The fifth element of negligent parental supervision is that Hayden Duran, the parent, was aware of all these risks, that's element one, and did not act responsibly or reasonably in executing those risks. When it comes to determining the amount of reasonability of response, so what Hayden should have done in response to Jesse's misbehavior, it is necessary to know the extent to which Jesse misbehaved. So how could we make a judgment as to whether Hayden did or did not act responsibly if we do not have full context of the actions which Hayden did have knowledge of? So knowing that Jesse is violent is very different if Jesse's violence was manifested itself in shooting other people before, or whether Jesse's violence manifested in, being belligerent in class when people said stupid answers. I don't know, something very, very minute. So the nature of the events is important, and it's an essential element because they're necessary to explain how Hayden Duran responded and the efficiency and effectiveness of Hayden Duran's response. I don't think it's great response, but it is a response, and that's how I believe this argument will go. In conclusion, I think that it's really important to try and make this objection. I think that Rule 405 is something commonly misunderstood by people across the mock trial community. I think that we have a first step where we're out in front of the pack, so to speak, when it comes to this rule. And I think that it has a lot of implications when it comes to Park v. Duran in particular, because much of the plaintiff's case, regardless of case theory, is going to end up being character evidence. And I think you can catch people off guard, especially early in the year. One last thing, just generally about reputation or opinion. There's a lot of contempt in the legal community, from what I've been able to read, about this 405A. Essentially, 405A is gossip. It allows for gossip. It allows for unsubstantiated opinions. It's kind of why it's not straightforward. You would think the specific instance that underlies the general opinion would actually be necessary and not frowned upon being admitted into evidence, because you don't want to have, like, I can just say, I think Matthew Covert is a dumb baby, but if I don't have any evidence supporting that, if I've just given no basis for that opinion, then it matters, and then it weighs less. So it's almost counterintuitive that I'm allowed to say Matthew Covert is a dumb baby without underlying the reasons or the specific instances which informed me of his dumb babiness. So there's a lot of contempt about Rule 405 and about how reputation is admissible, but specific instances of conduct are not. It adds an additional wrinkle in arguing this. Few judges will have the in-depth knowledge of the rules or of that debate to really be able to entertain you on it, but it is there, and it's important to know, especially if you are going to use 405A in particular, if you're going to try and rebut against someone objecting to you using general opinion. I wouldn't say change any of your instances of conduct. I think that there's reasonable responses if you have them currently scripted into your directs this year or in your future. But it is important to know this rule when it comes to evaluating this type of character evidence. Hopefully this helped. I know it was a mouthful, but thank you for watching.